On December 22nd, 2009, Tip News Daily had the opportunity to sit down and speak with local attorney Mark Bamberger. He spoke with us about a current civil litigation that he is working, as well as the Sunshine Law and fair employment practices. Here's a little bit of our discussion.
As is common, I meet with a number of clients who come with different issues. This was a case tied to employment law. And I spoke with Quincy about the situation that happened to him, that like I had been in past years, an adjunct professor, working term to term. It's a difficult type of contract.
Right.
And also here in Ohio, it's an at-will state, meaning that it doesn't take a whole lot to get rid of someone. You can get rid of someone effectively for no reason or for a good reason. But what you cannot do in Ohio is get rid of someone for a bad reason. This was that case that I think my client had been doing an excellent job at the college, at Edison College, and began to go to the board meetings there, which is a constitutionally protected action. Taping of a board meeting under Ohio's Sunshine Law is also a protected, acceptable activity.
Sure.
And so he decided, for whatever reason, that he wanted to tape that meeting. Now, the head of the board specifically identified that it was being taped and said words to the effect that he would rather it not be. But again, under the Constitution, federal and state, he was within his rights to do so. Subsequent to that meeting, word began to get around that the powers that be up to the president of the college were upset about that. And it would appear, at least we allege in the suit, that specifically due to the taping of video at that meeting, my client's job was ended. That is an unconstitutional issue.
Sure.
And both based upon federal law in the First Amendment, as well as state law.
Right.
He was doing something that he was legally allowed to do, and should not have been, as we allege, punished for doing that. In addition, some of the senior folks at the college began to say things about Mr. Essinger that were considered, we allege, to be defamation. Things were written, so there was libel, there was slander, because things were said, were published as the statute states, or the case law supports, to a third person. Emails were circulated around the college, some of which we have, others of which we will get when this goes down the road into the discovery phase, where there are interrogatories, questions asked, depositions that are taken. So I think that this is a very interesting and important case, and we intend to pursue it.
Right. Now, in the state of Ohio, two of the largest employers are, the state government and education. Really, I mean, so the educational institutions employ many tens of thousands of Ohioans. Now, you would think that they would have a keen eye on the Sunshine Law and understand employment law as a practice, right? As an institution, do you think that that there was something awry there at Edison, or where? What do you think that they needed to do better? I guess
Well, I hesitate to speculate, but certainly it's been in the news that there have been some ongoing issues at Edison. I know that the president suffered a vote of no confidence some times back. Latest information I have is that enrollment is up. The college seems to be doing pretty well,
right.
But yet there are some adversarial elements there that seem to be posing issues as far as the administration of the college. Other than that, I really can't talk about the internal workings. Sure. I will say, with reference to the Sunshine Law, that it has been my experience that universities and public entities know what that is, and know that these meetings are absolutely open to the public. When they are open to the public, that means that they can be taped. Now, there are aspects of a public meeting that can be held private. The board can go into what's called executive session to discuss sensitive things as far as personnel issues, budget issues, and such. So there is the ability to go behind closed doors to deal with those matters. Right. This was not the case. This was an open discussion. There was no executive session. My client in no way was disruptive or loud. If you know anything about my client, he's a very respectful, mild-mannered gentleman, and so I would not do that.
Right. So basically, he was there at a meeting where salaries weren't going to be discussed. Personnel issues and financial issues for the university wasn't going to be discussed. It was pretty much a standard type of meeting that is open to the public.
Yes.
And he brought a camera in to record it, which is his right. Okay.
Yes, it is.
Wow.
Yes, it is.
The plaintiff's case, you mentioned civil conspiracy. Can you explain what that is exactly?
It's a really interesting term, because you think of conspiracy as being FBI and CIA and usually a criminal matter. But of course, the term civil means that it's in civil court. And legally, it is defined as the organization of two or more folks within that group to do something wrong. Okay. It has much of the same sense as what folks would think of on a law and order, for example. But of course, that would be criminal. This is a civil issue where there is evidence, we allege, that two or more senior folks within the organization, here being Edison College, conspired or worked in concert to effectively get rid of my client based on what he had a constitutional right to do. It would have been different if he was a bad teacher, if he was doing something unethical. Again, at-will state here, so it's not difficult to get rid of somebody, but you can't do it for an unconstitutional reason. And unfortunately, this has had significant effect on my client. Not only was it done right before the term began, which made it virtually impossible for him to go anywhere else, but with some of what we allege to be the defamation that took place, that gets around, and it has made it increasingly difficult for my client to ply his trade, which is being a professor.
Right. Wow. Well, good luck with your case.
Thank you.
Hopefully we'll be able to meet up with you again and get some information as the case is resolved.
Happy to.
All right. Thank you, Mark.
Thank you.
Appreciate it.
Thanks, Mike.